Welcome to Law and Life, the Levoritz Approach.
Hello and welcome to Law and Life, the Levoritz Approach with attorney Yoni Levoritz. Yoni is the founder of Levoritz Law Firm and is recognized for his exceptional skill in family law, his compassionate manner, and his commitment to achieving favorable outcomes for his clients. I'm Kevin Rosenquist, and in today's episode, we're talking about high conflict co-parenting in New York and how communication issues can affect custody, decision-making, and the direction of the case. Yoni, welcome back.
Thank you for having me, Kevin. Glad to be here.
Absolutely. I'm excited. This is an interesting one. It's definitely, I'm sure, can get very heavy. In a New York custody matter, what tends to indicate that communication between co-parents has moved into a high conflict pattern rather than perhaps an ordinary disagreement?
Let's start with the basics of the high conflict part first. Most parents are getting divorced because they can't talk to each other. The inability to communicate is one thing. If it's abusive, it's another. So we have to take it step by step. Typically speaking, in a high conflict divorce, people are throwing text messages at each other on a regular basis. You didn't do this. You didn't do that. You failed to pick up the kids. You picked up the kids too early. You let the kids stay home from school. You didn't take the kid to the doctor. That's just a typical high conflict divorce where you have lots of text messages flying back and forth. And for that, they have developed numerous apps that you can use on your phone to communicate with the other parent, which documents everything that you write to each other. And people are much more controlled when they have access to those apps.
Mm-hmm. Yeah,
okay.
I've heard of those.
Yes, they are wonderful apps. They help with the conflict. They help with reducing the conflict. They don't let you use certain words, okay? Which is even better because if you've got the person who's causing the high conflict, you really don't want them using those words anyway.
Right.
So you put yourself in a position where you try and have those apps put in place as soon as possible by the court, by opposing counsel, by you, by whatever you can do to make that work so people can communicate freely but non-abusively.
Mm-hmm.
Then you've got the ultra high conflict issues, where they're really abusive. Those you seek orders of protection for. Because then you're dealing with a situation where the person is out of control and you need protection from them. And therefore, the courts typically cut off communication based upon what's typically called aggravated harassment or other things of that sort.
What about just bad communication? Like poor and inconsistent and not communicating. Does the court look at that poorly, as strongly?
When you're dealing with communication issues, okay, again, the apps are really the way to go. But if you're dealing with it on a text message basis or a phone call basis, you must make sure that the person records everything. The person records the phone calls. The person records everything because they're going to be on defense, okay, if they're not informing you of the doctor's appointment, if they're not informing you of the kid's haircut, if they're not informing you about the kid's karate lessons, if they're not informing you about soccer practice on Saturdays. Those are real issues. You're going to be on defense if you're not informing the other person. In large part, you're sabotaging them from being an active co-parent.
Right.
Courts are going to look at that with an eye towards, hey, this person can't foster a relationship. This person is actively sabotaging the relationship. On the other side, you've got the person who's on offense, who's making the claims regarding communication, and therefore they're the ones who are going to be accusing the other parent of lack of communication. Both of them should want the app. Both of them should want a calendar that's shared that can show when they took care of the kids, how they took care of the kids, the doctor's appointments are properly posted, therapy appointments are properly posted, and they can go ahead and work together.
We talk a lot about the child's best interest, kid's best interest. Is it sometimes, parents just kind of get lost in the emotion and stop thinking about the child's best interest? Is that something that tends to start these sort of issues?
It happens all the time. Some parents just focus on the win. Some parents really don't care much about the kid at all. They just don't want to pay child support. They just don't want to pay maintenance or alimony. They want to have a better economic position. They stayed at home. They're going to be able to, sometimes you have dads who stay at home and moms who stay at home. and they're going to say, hey, I'm a stay-at-home parent. Therefore, I'm the one who took care of these things. Why should I share with him now? Why all of a sudden now is he coming to doctor's appointments? This is my domain. This is my area. And they don't realize that, yes, it was your domain, but sometimes when parents start getting divorced, it becomes both parties' domains because you're not seeing your child as often. It's an extra opportunity to see your child. It's an extra opportunity to say, hey, I'll buy you an ice cream after you're done taking that shot. It's a nice thing to have for, again, depending upon which side you're on, but parents typically try and sabotage these things one way or the other. It's rare that you find a really good parent who says, listen, it's our child, not my child. Okay. And therefore, it is something that we deal with together.
What are some of the factors the courts might look at to determine whether a parent is contributing to the conflict or making it harder to co-parent effectively?
They're going to be looking at all those communications because every text message you send is going to end up in evidence at some point in time if it involves a communication between the parties. People are going to use it to play one way or another. They're going to use it to show that they communicated nicely, that they can foster a relationship, that they involve the other parent, or it's going to be used in the alternative to show you're not fostering the relationship and you're not fostering the process and you're trying to cut them out of the relationship. So those text messages, no matter which side you're on, are going to be used for one purpose or another.
When you're trying to kind of, coach or help your clients understand that they're in a high conflict situation and that they need to stop throwing coal on that fire, are they generally receptive to it? Is it a hard thing for them to understand? I'm sure it's case dependent, but maybe perhaps a better question is, how do you help them understand that this is important and that they need to kind of like check their emotions at the door?
Oh, the way you explain it to them is in terms of winning or losing. Okay. You explain it to them based upon the fact that, listen, if you don't do these things, the judge is going to not like you. The judge is going to be unhappy with you. You don't want to annoy the trier of fact. You don't want to annoy the person who's hearing all these facts and all this evidence. And a father claiming or a mother claiming, if you give him or her custody, okay, I'm not going to have a relationship with this child. So you explain to them, doesn't matter how you feel, doesn't matter what you think. If you want custody of the child, you're going to walk the high ground.
Other than text messages and apps, what other documentation do you recommend during these high conflict situations?
Well, I don't recommend text messages. Text messages people just send off at the craziest hours, the craziest times. They go ahead and they make wild claims. They use foul language. I don't recommend text messages at all to either side. If you're going to use text messages, I like a 15-minute rule, which is you read it, you put down your phone, you think about your response, you calm down, you make sure it's a measured response, and then you send out a text message. After you've read it, after you've drafted it, after you've put it together, and you think about it again and again and again before you send it.
Is there other things that you encourage people to document to help their case?
Sure. They should be documenting everything that shows what they're doing and the other parent is not doing. So, for example, husband misses a doctor's appointment. It was an important one. Document it in your calendar. Don't share it with him because you don't want to tip him off that missing appointments is a bad thing for trial. Okay? So let him fall into his nice little comfort zone or her nice little comfort zone. But you want to put yourself in a position where you have the ability to say, they don't show up for doctor's appointments. I just tried a case where we had numerous examples where the father is seeking a 50-50 split, but he didn't show up for some of the most important doctor's appointments of the year for this particular child. How could you give him medical decision-making? How could you give joint custody? He's not showing up. He's not doing his part. And we had the dates and the times and the places and everything else to confront him with. And for my client to testify about as a result of the fact that they did not go ahead and document these issues. They went ahead and put them in their calendar and did not tip the other side off. It's very important. Do not teach the other side how to behave.
Interesting. And when it starts to affect the child's stability, their schedule, their ability to maintain routines, does that shift a custody case once you kind of really see that this fighting between the parents is starting to truly affect the children?
Yes, it absolutely does. That's a very big negative thing, and the court is going to point the finger at somebody for that negative ramification, or both parties for that negative ramification. Courts do not want children involved. Courts are much happier when people are behaving themselves and not involving children.
Yeah, or I think we've talked about before on this show, pitting kids against the other parent.
Happens all the time.
Yeah.
Dealing with a bunch of cases like that right now. People pit children against their parents. And when the children become older and teenagers, changing that status quo is extremely complicated and difficult because the children have now adopted a strategy based upon the other parent. And they don't like the opposite parent, the father or the mother, as a result of being brainwashed and being told, listen, they're no good. They don't do this. They don't do that. They don't pay child support. Everything's on me. Woe is me. I'm the victim. Sympathize with me because I'm the victim. They make children choose sides. Judges don't like that.
Yeah, I would imagine.
And it's horrible for children.
Absolutely. I can't even imagine that. Yeah, that sounds, yeah. What an awful position to put a kid in.
Yes.
Yeah. A lot of times I feel like you're going to have one party that may be a little more aggressive with the conflict than the other one. That other one might react when they maybe normally wouldn't, but they do because they're angry and all that. For anyone listening who's got a high conflict, co-parent, what kind of advice would you give them to start?
If you're dealing with a high conflict co-parent, try and ignore them for short periods of time. Because typically the high conflict parent is going to hate being ignored. And they're going to write text message after text message after text message, making wild and ludicrous claims just because you ignore them. If you feed into them, they're going to argue back with you, and you're going to be stuck in an argument. But if you ignore them, you may be able to gain a lot of traction with some good text messages.
Yeah, that's a good point. Text messages usually escalate if you ignore someone. If they're not feeling heard, they're going to get real angry. And then I suppose that's ammo, huh, for the court?
It's ammo for the court. It is a beautiful thing to have happen. It happens quite frequently. People lose their tempers and just feel, oh, they're ignoring me.
Mm-hmm. Yeah,
and
you're right, though.
It's a
I
great
totally agree.
strategy to use.
I totally agree. I mean, yeah, ignoring someone who's being unreasonable or kind of a jerk, yeah, usually makes them more angry than if you said something, and sometimes that can work in your favor.
Yes, absolutely. And it's a strategy that I teach my clients. We have other strategies as well. I mean, sometimes what pits people off. Sometimes saying, I'm out right now, okay, makes husbands to a certain extent think, oh, they're out with another man. Oh, they're out with another man. And they start texting you and start texting you and start texting you. There are a lot of strategies to use.
Wow. Yeah.
Jealousy is one of them.
That's interesting. Yeah. Huh. We'll have to do a whole episode on that.
On jealousy, we certainly could.
Yeah, right.
There's lots of ammunition to come from just basic little drops that have no meaning to the court when the text message comes through.
Mm-hmm.
Because the other side is just so obsessed, they can't let go.
Mm-hmm.
Which is why therapy is important for divorce litigants.
Yeah, that is definitely a good call. I believe we've talked about that before, and I've definitely heard that before from other lawyers that is something that is highly recommended in divorce cases.
Yes, people should seek counseling.
Yeah. All right.
Preferably from a therapist who doesn't keep notes, by the way, because those notes are admissible in court. So you want a therapist who's just going to listen to you and not take notes.
Oh, so you don't want the notes.
You don't want notes. You don't want any documentation. You pay cash, you go, you sit, you do. And if you're asking if you're seeing a therapist, you see the therapist and you admit to it because you can't lie. So God forbid, no one should think that you can commit perjury. But you can go ahead and ask the doctor not to take notes. And therefore, it's all based upon their memory. Because there's no doctor-patient privilege in custody cases.
Okay. That's a good point to bring up as well.
Just one thing to remember.
Yeah. One of many.
Yes. In a field full of landmines.
Right, right. All right, well, thanks for joining us today on Law and Life, the Levoritz Approach. To contact Yoni or learn more, visit leveritzlaw.com. For more insights on navigating divorce and family law in New York, be sure to subscribe to the show. Leave us a review. We very much appreciate it. Yoni, always appreciate chatting with you. Thanks so much.
Thank you for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.